All right, good morning, everyone. You're here at First Appearance Court this morning. I'm going to make some preliminary statements and explain to you why you're in court this morning. I'm also going to advise you of certain rights. Florida law requires that you appear in front of a judge to be advised of the crimes that you've been charged with and to let you know the amount of the bond, if any, that is set on each of those charges. There are a group of cases today where your case has already been assigned to another judge. That judge signed the warrant for your arrest, which is why you are in court today. And in signing that warrant, that judge decided whether you would get bond or not. Those types of violations include probation cases, a failure to appear at a prior court date, or a failure to meet drug court requirements. Because that judge already has authority over your case, whatever the judge decided in terms of bond will not change this morning. And if you want any change in your bond, you will have to go back in front of that judge. Today's proceeding is not a trial. I won't determine whether you're guilty of the crimes you're charged with. I will determine in each case whether there is probable cause to believe you committed the crimes you're charged with, and in any given case there is no probable cause, I will specifically state that on the record. It's also important you understand that everything being stated here this morning will be electronically recorded. Whatever I say, whatever the attorneys say, whatever you may say is going to be recorded this morning. In every criminal case, a person charged with a crime has a right to remain silent. That means you cannot be forced or compelled to be a witness against yourself in your criminal case. Because of your right to remain silent, I am not going to ask you any questions about your case. You are not required to tell me anything about your case. And if for whatever reason you make statements about your case this morning, I want you to understand up front, your statements will be recorded and will be used against you in the future. Another important right you have is the right to an attorney. I don't see any private attorneys here this morning. Unless you tell me you've hired a lawyer because you're in jail this morning, I'm appointing the Office of the Public Defender to represent you at today's first appearance. If you want the public defender to represent you after today, you will have to fill out a financial affidavit, and if you qualify, they'll represent you in the future. You have a right to communicate with counsel, family, and friends, and if necessary, will be provided reasonable means to do that. There's another group of cases involving domestic violence offenses. It could be a battery domestic violence by strangulation, violation of a domestic violence injunction, or aggravated battery on a pregnant female in a domestic environment. In all domestic violence cases, there is an administrative order in Hillsborough County that when you're arrested on those charges, the order requires the jail to book you in with no bond, and you're held with no bond until you come to first appearance court. In deciding whether I will give you bond or not in those cases, I'll do a couple of things. I'll review the criminal report affidavit, which is basically what the officer alleged occurred based on his or her investigation. I'll listen to the state attorney, I'll listen to the public defender or your private attorney, and if there are any alleged victims who want to testify, I'll listen to them as well. After considering all that information, I will make my decision regarding your bond. It's very important you understand that in all domestic violence cases, I will impose special conditions of your bond or release. These are requirements you have to follow while your case is pending, and it will include these conditions. The first is a no contact order, directly or indirectly with the alleged victim. If I impose a no contact order in your case, that is what it means, and it says what it says. It means you are to have no effort to try to contact or communicate with the alleged victim while the case is pending. That means no phone calls, no texts, no emails, no letters, no use of social media. It also means you're not allowed to be at any location where the alleged victim is at any point in time. You don't go where they live, where they work, or where they go to school. If they are at a location, you are not allowed to be there. The other part of the no contact order is indirect contact. That means you getting someone on your behalf to try and contact or communicate with the alleged victim. It's typically a family member or a friend. It doesn't matter who it is. That is also a violation of the no contact order. In all cases where I impose a no contact order, and I will do it in some other cases such as robberies, burglaries, or theft, you will be handed a copy of the written no contact order while you're in court, and you will acknowledge receipt of the order before you leave court this morning. All right, the first matter up today is on page 48. Reuben Foster.
Present order, Your Honor.
All right, Mr. Foster, good morning. You're charged with battery, domestic violence, no bond set. What says the state?
Your Honor, we're asking for a $2,000 bond. He has a prior DV bat from California that was dismissed with the same victim. He also pled to an illegal possession of an assault weapon on that case in California. That's why we're asking for the $2,000 bond.
What's his defense?
Your Honor, Mr. Foster is gainfully employed. The alleged victim is his ex-girlfriend. They do not reside together, nor do they have children in common. That prior domestic violence case was, I believe, ultimately dismissed. I'm requesting he be released on his own recognizance with no contact.
Okay, the court finds probable cause to charge domestic violence, battery, imposes bond amount $2,000, no contact order with the alleged victim, no weapons or firearms. All right, we're going back to page 1 of the docket. Jonathan Alejandro Zabetic Every.
2,000 no contact.
He's standing.
Okay, Mr. Zabetic Every, good morning. You're charged with battery, domestic violence, no scheduled bond, possession of controlled substance, scheduled bond $2,000. What's his state?
Your Honor, he has no priors. We're asking for standard bonds.
Defense?
Requesting $500.
Okay, the court finds probable cause on both charges, imposes bond $500 on the battery, $2,000 on possession of controlled substance.
And no contact and no firearms, Your Honor?
No contact with the alleged victim, no weapons or firearms. Tira Ann Selly.